Michael Popok, it's time for my Legal AF hot take. You have already heard that the United States Supreme Court, the Anderson decision, overturned the Colorado Supreme Court's decision that Donald Trump was an insurrectionist, engaged in insurrection, and could be banned by the Colorado Secretary of State from the ballot for federal office. That you've heard about. But let me take you through the Anderson decision and tell you what the ramifications are by the 5 votes on the United States Supreme Court, not including, apparently, Amy Coney Barrett, Sotomayor, Kagan, and Ketanji Brown Jackson, but the majority, the 5, Kavanaugh, Gorsuch, Roberts, Alito, and Thomas, what they've done to insulate Donald Trump and what needs to happen next when there is an election to elect a new Congress, because it is Congress, the 5 members of the United States Supreme Court say, that has to set up a system, a judicial system, another mechanism in order for insurrectionists in the future to be barred from the ballot, because they're not allowing the states to do it in a nonsensical analysis in which, in one hand, out of one side of their mouth, they say that the states are allowed under the 14th Amendment to bar and ban state office holders and candidates who are insurrectionists, found out by the state, adjudicated by the state, but they can't do it under the federal candidates because of the existence, they say, the majority, of not Section 3 of the 14th Amendment about the insurrectionists that are disabled from running or from holding office, but Section 5 of the 14th Amendment, which they say is a mandatory enabling clause that Congress must pass laws to effectuate the terms of the 14th Amendment, even terms such as exist in Section 3 that are self-activating, that are self-affecting, makes absolutely no sense. How could the states be able to disqualify state candidates, right? But they can't disqualify federal candidates because, Section 5 exists for both, which, that internal inconsistency, which they completely ignore in their analysis, is at the heart of this disingenuous reverse engineering. They wanted to reach a political result and conclusion, the majority, and so they did. And then they floundered around to try to find something in the text of the Constitution, anything they could hang their hat on, even if it doesn't apply. Because there's no way that Section 5, the enabling clause, if you will, applies to Section 3. It just can't be. Section 3 says if you engage in insurrection or rebellion against the Constitution, you cannot hold office. It doesn't say subject to Section 5. Section 5, I grant the majority, applies to other additional laws to enforce the constitutional amendment, to enforce it. So in the constitutional amendment that's supposed to restore civil rights to newly freed slaves who are now freed Black Americans, I get it that you have to, as a Congress, empower them, and that the drafters of the amendment empowered Congress to sort of, fill in, connect the dots, and produce new law to effectuate the principles of the 14th Amendment and its attempts to restore civil rights to those that have been disadvantaged and enslaved. Yes. So you pass voting rights laws. You pass laws to make sure that the Black Americans' right to access to the ballot is not disenfranchised in any way. So there's there's other laws under Section 5 of the 14th Amendment that have to be passed to put into place and implement the 14th Amendment, but not Section 3. Section 3 on its face is self-contained. It says exactly what the framers wanted it to say, and that automatically anyone who engages in insurrection has to be taken off the ballot and not be able to be seated unless Congress takes away that disability by a 2/3 vote. Now, the Supreme Court pointed to that and said, oh, see, Congress, all roads lead to Congress on a federal office. States don't have a role in federal offices. Yes, they do. There's a long line of cases by the United States Supreme Court, just not this one, that said that states, of course, handle the manner and means of voting in their states, what the ballots are going to look like, including for federal elections. There's federal electors for which they have responsibility. And they have the states have plenty of roles. But John Roberts, in the oral argument related to the Anderson decision, laid it out. We knew this was coming because he said, well, I see all of the 14th Amendment and all of the Reconstruction era post-Civil War amendments done to stop renegade and rogue states from acting against the federal powers. In other words, it was to reestablish the supremacy of federal law and federal power over the republic that had just gotten through the Civil War and the rebellion against Abraham Lincoln and the republic. I get that. But in this particular one, they missed the historical precedent. I mean, there were plenty of briefs that were supplied to the United States Supreme Court, plenty of amicus briefs they could have read. 25 of the leading Civil War scholars all got together, Civil War scholars on law and the Constitution, and told the Supreme Court, Section 3 rises and falls on its own merit, doesn't need any other enabling statute or legislation to be passed. But now we are where we are. The purpose of this hot take is to tell you where we are and why the election in November is so important as we sit at the intersection of law, politics, and justice. Now, based on the Anderson decision, which, yes, all 9 justices agreed, as Amy Coney Barrett liked to, in her one paragraph, like to pat herself on the back, that during these trying times, it's time for the Supreme Court to lower the temperature of the body politic and not raise it with our words. Okay, thanks, Amy. Thanks. Thank you for that. A little advertisement. This ad brought to you by the United States Supreme Court, whose reputation and ethics lie in tatters at the feet of the American populace. But having said that, what happens next? Based on this ruling, Congress and whoever's in charge of Congress will need to establish a new set of statutes, which details exactly how disqualification based on insurrection will happen. Who will determine it? Is there going to be like a congressional court? Sort of like the courts they use for impeachment process for sitting officers of the federal government? Is it going to be, so it's going to be a House court? Or are they going to enable federal courts or maybe even state courts, because I guess they can, to effectuate? That's the problem right there. I just pointed it out. It just dawned on me. That's the problem with the Supreme Court decision. So why can't Congress in their world they just created, why can't they delegate to the states like Colorado and all the rest of the states the right to determine for their own whether someone's engaged in insurrection or rebellion to put them on the federal ballot or not? But let's say they keep it in the federal court system. They're obviously going to either use the court system or they're going to have to set up a mini insurrectionist court system, sort of like martial law within Congress. Not that they're suited as members of the legislative branch to conduct trials, but I guess they could do that. And by the way, this is exactly what the framers of the 14th Amendment and all the amendments coming out of the Civil War era didn't want to have happen. National trials to determine whether somebody is an insurrectionist and whether they should be on the ballot or not. They were afraid that would tear apart the Union, right? They had enough with Jefferson Davis being prosecuted, as the first president of the Confederacy on the return. And the other problem historically, back to the Anderson decision for a minute from a week ago, is that there's not one rebel leader who left the Republic who got disqualified from the ballot the way that the Supreme Court just said they needed to be. Not one of them got disqualified by an act of Congress, an enabling statute, an enabling declaration by Congress, which completely undermines, of course, the Supreme Court's misuse of Section 5 of the 14th Amendment as they floundered around to find something in the Constitution as originalists and textualists they could hang their hat on. So where are we now? The new Congress, and you see where this is going, depending upon who controls it, Democrat or Republican, if it's Democratic controlled, if the American people send Joe Biden back to the White House, along with control of the Senate and the House, then we'll get a series of laws established to enforce the 14th Amendment, Section 3, right? We'll get a code book We'll get something in the Code of Federal Regulation, the CFR, that outlines, like the IRS manual, exactly what will happen in, the rule book, the owner's manual for how to get rid of insurrectionists like Donald Trump. Well, I assume they'll delegate it to the federal U.S. attorneys, to the Department of Justice, in the hands of whoever sits in the White House and his U.S. or her U.S. attorneys. And a process. I don't think they're going to create a set of statutes, especially if it's democratically controlled, that will require congressional, national trials or tribunals to determine if somebody's an insurrectionist. But somebody has to decide it. As they said in the Anderson decision, see, that's what the Colorado said. Somebody has to determine who engaged in insurrection. We agree. It's just not state by state. Okay, so what do you want? Congressional tribunals? All right, so maybe that's what Congress does. But the point of the hot take is this is going to turn on whoever gets the House. It's a race here, a race to save democracy. If the Democrats get the majority of the House, they'll establish, I assure you, in their first term, in their first 6 months, a series of laws and regulations enabling the 14th Amendment, Section 3, to prevent future insurrections. Because without this firewall being established now, which now the Supreme Court has ripped out of the text, there was a firewall, and the Supreme Court just disabled it, just emasculated it, just ripped it out by the root of its hair from the Constitution, meaning the Congress is going to have to put it back in. And if without that firewall, we'll have worse than Jan 6 next time. Donald Trump loses in November, they'll burn the city down. They'll actually accomplish what they tried to accomplish. They'll assassinate elected officials. Now let's look at the dystopian world that Donald Trump resides in, of the Republicans winning the House. Then they won't establish any rules or regulations to enable and enforce the 14th Amendment, Section 3, and the Supreme Court can't do a darn thing about it. The Supreme Court is not a court that through a mandatory injunction or mandamus can force the Congress. I mean, there'll be lawsuits. We'll cover them here on Legal AF. Somebody will file a lawsuit to force Congress through a writ of mandamus to compel them to implement and pass implementing language for the 14th Amendment, Section 3 to stop insurrectionists, and they won't. And the courts will then throw up their hands and say, it's a political issue. It's a political issue, and we don't touch political questions. We're not a body politic. We're a body of law when they want to be. Well, if they're a body of law, then riddle me this. Why is Amy Coney Barrett in her concurrence, which lasted all of a page and a paragraph, why did she use the following phrase? If they're not trying to get involved with politics and they're not trying to be activist judges, the same kind of activist judges that conservative Republicans accused for years, courts like the Warren Court and other courts of the United States Supreme Court. How do you explain, how do you reconcile this statement by Amy Coney Barrett? She says, the majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency among the court, she's talking about. The court has settled a politically charged issue. That's very telling. She just said the quiet part out loud. So the Supreme Court put its big fat finger into the pie of political issues when they have doctrines that say they shouldn't. The court has settled a politically charged issue. Exactly. At the volatile season of a presidential election. Well, here's somebody who's woken up and told the world exactly what's happening there. They're putting their big fat finger on the scale of justice in favor of Donald Trump. She went on to say, particularly in this circumstance, writings on the court should turn the national temperature down, not up. Did she feel that way when the Dobbs decision came out? Did she feel that way when the Dobbs decision ripped away a woman's constitutional right to choose and bodily autonomy and right of privacy about her most intimate decision-making about family planning and giving birth or not? and ripped away a woman's right to choose enshrined in the Constitution and preserved since Roe versus Wade? Did she care about now is the time to turn down the national volume of acrimony? She did not. But I do appreciate, using the decoder ring here, I do appreciate that Amy Coney Barrett said the quiet part out loud. We, as a Supreme Court, are going to involve ourselves in an activist way in politics. And we're going to rule in favor of one side and not the other. And that was in the side of Donald Trump. Because nowhere in Section 5 is there a requirement that Congress pass an enabling statute or do any kind of enabling. But now they're going to have to. And so we're going to follow. And what can you do to affect the outcome? This is one of these rare shows, one of these rare analytic hot takes where you, the audience, can actually do something and affect the outcome, right? This is like one of those video games where you have alternate endings and alternate outcomes, and you can choose which one you want to play. You have alternate outcomes, and you can choose which one you want to play. If the Democrats get the House, then they will pass the required legislation in order to stop insurrectionists from ever holding office again, likely through federal courts and attorney generals in the Department of Justice. The Republicans get the House, they won't. And we will have worse on Jan 6th, including many of the same people on Jan 6th, led by the same cult leader on Jan 6th, and worse in the future. The choice is yours. The choice I had was to do this hot take, and we do it also on a show we call Legal AF every Wednesday and Saturday. The name means exactly what you think. It's a cheeky name for what we do, and we pull together and curate for you the top 4 or 5 stories at the intersection of law, politics, and justice that you need to know about. And we do it then on hot takes to catch you up right here on the MeidasTouch network. Almost 3 million strong. I mean, they got another 800,000 to go, but you can be part of that. Speaking of making a choice, use your thumbs and fingers, free subscribe. The bigger that network gets, the bigger our network gets, the more your voice is heard, and you're building the network that we reside on, and you're getting the content apparently that you enjoy. If you like my content, take a second, thumbs up, please. Leave a comment. It really does help. It's not just pandering for ego sense. Yeah, sure, I like the numbers. However, it also keeps us on the air and lets the algorithmic gods know that this is the kind of content that you want to continue to see coming at you. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.